I'm going to start the introduction of our panel members and get our panel going. As I'm doing this, they'll proceed and finish what they have in their mouths and come up to the table. First, I want to welcome all of you here. It's great, and we have a terrific turnout for this. I want to thank the Federalist Society for sponsoring and putting this on, and I also appreciate the cooperation that the American Society for International Law has done as well. I'm not going to spend a lot of time. You came here to hear our panelists, not hear me. I also assume that all of you can read, so I'm not going to repeat either what is on the brochure, the leaflet that you have, sort of giving you a little bit of background on the ICC and the Kampala Review Conference. Also, I think all of our panelists will be known to you, and we provide enough facts, I think, to give you some idea that they should know what they're talking about. So we're going to get started. We're going to start letting Michael Scharf sort of set the scene for us as to what went on. And Brian, Jeremy, and Richard, why don't you all come on up and join me? As to what went on at Kampala. Then we'll hear from Brian Hook, who was Assistant Secretary for International Organizations at the State Department, and therefore understands how these organizations work. Then we're pleased to have Richard Dicker, who is the Director of the International Justice Division at Human Rights Watch. And then our last panelist will be Jeremy Rapkin, a well-known professor of international law at George Mason. And so we'll try to ask the panelists to sort of keep their comments down to sort of 10 to 12 minutes. We'll have a little banter back and forth among us when they finish, and I hope that will leave plenty of time for some Q&A from the floor, and we'll have you out of here at 2 o'clock. Okay. Michael?
Thank you very much, Edwin. It's very good to be here today, and thank you to the Federalist Society organizers of this event. Let me begin with a quotation from the Nuremberg Tribunal 65 years ago. Nuremberg famously said, "To initiate a war of aggression is not only an international crime, it is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole." Back in 1995, when the Yugoslavia Tribunal was created, and I was writing a book called Balkan Justice, which some of you may have read, I interviewed the prosecutor of the Yugoslavia Tribunal, and I said, "Why have you not indicted Slobodan Milosevic for his involvement in all the atrocities in Bosnia?" At that time, we thought that there was some kind of a quid pro quo deal that had been worked out. And he said, "No, it wasn't political at all." And I'm going to quote him. He says, "The evidence and references to Milosevic we have so far," he replied, "proved that he was responsible for beginning the war. But that's not a crime within the tribunal's jurisdiction. I wish it had been." Ironically, Richard Goldstone, on the eve of the review conference a couple of months ago, wrote an op-ed piece in the Wall Street Journal in which he said that the crime of aggression would be a disaster for the International Criminal Court. He may have been right or he may not have been, but he certainly was being inconsistent with what he was saying about the Yugoslavia Tribunal, where he said he wished more than anything else that he had had that crime in his arsenal so he could have prosecuted Slobodan Milosevic the year before the Srebrenica massacre. Now, in 1998, when the Rome Statute was negotiated, it provided jurisdiction for the International Criminal Court for war crimes, crimes against humanity, and genocide. Like the ad hoc tribunals, it left out the war of aggression, something that since Nuremberg had been anathema to the major countries of the world caught within the Cold War dance and the proxy and other acts that had been accused of being aggression from time to time. But as a compromise and a placeholder, in response to a colleague of mine who passed away last year, Henry King, and 2 other Nuremberg prosecutors who came to Rome and said, "Look, Robert Jackson would be rolling in his grave if he knew that you left out the crime of aggression. You have to put it in. Everybody knew that they weren't ready for it. The world was not ready for it. So they said, all right, we'll put it in the statute, but we'll say it only is activated once there is a definition that has been accepted and a trigger mechanism that has been accepted by the parties to the statute. And there was a formula for such acceptance. Well, that formula said that there couldn't be any discussion of that until there was a review conference 7 years after the ICC statute came into force. And so 7 years and about 11 months later in Kampala in May and June of this year, there was that review conference. I personally led a 6-person delegation of the Public International Law and Policy Group, a non-governmental organization whose summer associates are seated at the table in the far back, and which is made up of former members of the State Department legal advisor, and who Edwin serves as a prestigious member of our Board of Advisors. Before we went to Kampala, however, the Public International Law and Policy Group and the law school where I teach at, Case Western, had led a experts meeting that was co-hosted by the chairman of the Assembly of State Parties, Christian Wanavasser, in which we tried to brainstorm ways to come up with a formula that would be accepted to all on how to add the crime of aggression and have a trigger mechanism. The discussions in the expert meeting report are contained in this symposium issue of the Journal of International Law at Case Western, which is available online. Interestingly, those discussions were very prescient because a lot of these kinds of suggestions made it into the final decision. Now, at the start of the 2-week session, there was much skepticism, and at most, the delegates thought that there might be a definition and elements of crime that would be adopted, but that there was no possible way that all the countries there, 111 countries from all regions, including members of the permanent members of the Security Council, members of the NATO alliance, close allies of the United States, and the U.S. as a non-member participating delegation would accept some kind of trigger mechanism. Prince Zaid and Ambassador Wanavasser, however, the two co-chairs of the Diplomatic Review Conference, were very, very savvy. They were brilliant, creative, and tireless negotiators. They worked around the clock, meeting individually with every delegation repeatedly, and they started to build momentum for some kind of a compromise deal. The United States gave 3 speeches during these 2 weeks that are interesting to show what was going on in the U.S. and from the U.S. perception. The first was by the head of delegation, Stephen Rapp. Stephen said in his speech, and I'll just summarize briefly, look, I used to be a prosecutor of a war crimes tribunal, the Special Court for Sierra Leone. I came up the ranks of the prosecutors. I love international tribunals. I think the International Criminal Court is a very important institution, and I have to tell you that if you adopt the crime of aggression, you will kill this beautiful baby that you have created. So let's not kill the baby, let's keep the crime of aggression out of it. Well, then Harold Coe, at the end of the first week, gave his speech, in which he outlined the objections, the concerns, and the many questions that the United States said had to be answered before you could move forward with the crime of aggression. A very negative tone, and it was negatively received. Then, as momentum continued to build throughout these 2 weeks, Colonel Bill Litzow from the Department of Defense, who had been a member of the delegation back at Rome, who's a brilliant strategist in his own might and knows all about International Criminal Court, gave a very positive speech, which signaled that the United States was starting to change its position here, in which he outlined conditions and understandings that the United States would like to see added to the compromise solution that was being negotiated. And basically he said if these things were accepted, the United States would not stand by and scream and yell from the sidelines, but would rather be supportive of the endeavor to move forward with the ICC with this new addition to its statute. Well, 8 minutes after midnight on the last day of the conference, the consensus was announced. And what the proposal did is as follows. The proposal is online. If anybody ever wants to get it, just look up ICC and aggression, and you can get the actual document. First of all, it adopts the definition and element of the new crime of aggression with a U.S. understanding The understanding is that the ICC would only have jurisdiction not over all crimes of aggression, but just manifest acts of aggression. And then, to make the understanding even further, they outline what it means to be a manifest act of aggression. The character, gravity, and scale all must be manifest, not any one of those. And manifest means clear and egregious. And the intention, according to the negotiating record, was that the crime of aggression within the jurisdiction of the ICC would not apply to anticipatory self-defense or even reasonable mistakes about imminent attacks. So, for example, the Iraqi 2003 invasion, take away the Security Council theory of implied authorization, would still not have been a manifest crime of aggression within the ICC statute. The other thing it wouldn't include are acts to prevent crimes against humanity or genocide, crimes that the ICC was in fact created to prosecute, and the idea was that the 1999 NATO intervention to stop the Kosovar Albanian potential genocide would not have been a manifest act of aggression. Now, there were further hoops built into the proposed amendment that was finally adopted by consensus. The first is that even though they decided to adopt this, it requires a new vote of 2/3 of the state parties after January 1st, 2017. In other words, a 7-year pause period to decide, did they make a mistake in Kampala? If so, maybe they're not ready to move forward. They have to re-endorse it before anything can happen. Secondly, there has to be 30 ratifications. Out of the 111 parties, or whatever number of parties there are, 30 of them have to actually ratify this proposed amendment. Now, there are exemptions written into this amendment. First of all, it specifically, and this again was at the U.S. urging, it does not apply to nationals of non-party states. No national of the United States, as long as we are not a party to the Rome Statute, can ever be indicted by the ICC for the crime of aggression, unless the Security Council refers the matter, which of course we can veto. Secondly, it doesn't apply to nationals of the parties which have decided to opt out. They created an opt-out process. And they can do so anytime, including now, before 2017. Again, the only exception to that exception is if the Security Council refers the matter. Now, the trigger mechanism that was adopted was that, first of all, there was Security Council referral. This, again, cannot happen until 2017, and it requires 30 ratifications as well. But when there's a Security Council referral, that's where the Security Council passes a Chapter 7 resolution. All 5 permanent members of the Security Council could veto that. They don't. They refer the matter to the ICC on an act of aggression. Then, and only then, the prosecution can investigate and lodge a criminal complaint. And even at that point, the court has to decide in its pretrial chamber whether to confirm such an indictment. Now, track number 2. Here, the prosecutor can inform the Security Council that he thinks there might have been a crime of aggression. This begins a 6-month clock. If the Security Council fails to either refer the matter or provide a red light, which is an Article 16 deferral resolution, where the Security Council tells the court, in the interest of peace and justice, stop this investigation. If the Security Council is silent, it doesn't either say, yes, there is a crime of aggression, or no, do not proceed, then, and only then, the prosecutor can go to the pretrial division. This is not the pretrial chamber, but the entire 6-judge division of the pretrial, and ask for authorization of an investigation. And even this takes a majority vote, and an investigation does not mean an indictment. That will take another hoop. Now, this track does not apply to non-parties or states that have opted out, like the United States, who is a non-party. Probably this means only 50 or 60 states of the 111 would be covered. It'd be sort of like the compulsory jurisdiction of the International Court of Justice. I assume it will have very limited actual consequences in the real world, but it might be the case that 2 countries that are negotiating a peace agreement who want further confidence-building measures would say, look, if either of us invade each other after we've negotiated this peace agreement, we agree that the ICC could have jurisdiction over the crime of aggression. That might give them more confidence. Very seldom would this happen, but it's out there as a possibility. Now, the effect on the United States. In June 16th, at an ASIL panel, Harold Coe and Stephen Rapp communicated their thoughts about how things went in Kampala. Quote, they said, the outcome of the review conference served U.S. interests. Quote, they said, while the U.S. didn't achieve the goal of exclusive Security Council trigger, the chances of prosecuting U.S. officials is 0, and the chances of a chilling effect is very low. Now, this panel is going to examine whether that's true or not, and I do have some concerns that they don't reflect. For example, what about a prosecution of a NATO ally who has not opted out and who is a party to the ICC statute? What happens when we are in a joint operation and our ally is accused for the very same operation of the crime of aggression? How will that affect U.S. policy? And also, what is the effect on national courts, criminal prosecutions under universal jurisdiction, both for crimes that are being prosecuted in foreign countries, and also, I suppose, if there is a person who is being prosecuted for, as in the UK, protesting around a military base, and they use the necessity defense by arguing that the invasion of Iraq in 2003 was an act of aggression, will this give a new defense to such people who are fighting against national security? So there's plenty to think about, and the other panelists, I'm sure, will give you much more to think about, and my job was just to map out what happened and where we are, and I'll be interested to see where they say we should be going from there. Thank you very much.
Thank you, Michael. Okay, Brian.
Thanks very much. And thanks very much to the Federalist Society for organizing this, and to Edwin for moderating, and also grateful to be on the panel here with my fellow panelists. The question before this panel is, after Kampala, should the United States change its relationship with the ICC? Professor Scharf was kind enough to provide an account of what happened in Kampala. What strikes me most about Kampala is how similar it was, in many respects, to the Rome Conference. And the similarities, I think, present an answer, a possible answer to the question before this panel. In Rome, we had a Democrat in the White House with a clear interest in seeing if an agreement could be reached for us to join the ICC. And I think, given U.S. history, this isn't entirely surprising. The U.S. insisted that promoting basic human rights and freedoms be included in the UN Charter. Eleanor Roosevelt chaired the UN Human Rights Commission when it drafted the Universal Declaration on Human Rights. We played a lead role in the Geneva Conventions. What's more, the United States supported the creation of international courts to prosecute gross human rights abuses. We pioneered the Nuremberg and Tokyo tribunals. We were a key supporter of establishing the ad hoc international criminal tribunals for both Yugoslavia and Rwanda. But when the U.S. negotiators arrived in Rome in 1998, they discovered that despite extensive efforts to reach an agreement, they were pushing on a closed door. The lead U.S. negotiator in Rome, a State Department official, made the following official statement after the conference. In Rome, we indicated our willingness to be flexible. Unfortunately, a small group of countries meeting behind closed doors in the final days of the Rome conference produced a seriously flawed, take-it-or-leave-it text, one that provides a recipe for politicization of the court and risks deterring responsible international action to promote peace and security. Fast forward to 2010 in Kampala, where again we have a Democrat in the White House, also with a clear interest in seeing if we could get to yes someday with the ICC. Secretary Clinton in 2009 said, quote, "It was a great regret, but it is a fact that we are not yet a signatory to the Rome Statute. But we have supported the court and continue to do so," end quote. A year before the Kampala conference, Ambassador Rapp announced what our red lines would be. He said that we would attach particular importance, as Professor Scharf just talked about. We would attach particular importance to defining the crime of aggression. He said that the Rome Statute should be amended to reflect the role and responsibilities entrusted to the Security Council, and the language defining aggression cannot be expansive or vague. President Obama sent a 30-member delegation to Kampala to do the negotiating. Ambassador Kapp and Harold Coe, have you heard, repeated our red lines and said the uncertainties surrounding the crime of aggression are too fundamental to be resolved at the conference. They expressed concern about the willingness of some member states to adopt the crime of aggression that we couldn't support. They said it was unacceptable to let the ICC clarify any uncertainties through future cases. And they said that if the crime of aggression is adopted, the prospects for the ICC to attain universal jurisdiction will be greatly diminished. And the result? The U.S. definition of aggression was rejected, as was our advice not to adopt the definition at the conference. It's true that we were able to clarify the definition through the addition of several understandings to the resolution in operative paragraph 3 that were adopted by consensus. And I think these understandings should guide the court to some extent in dismissing frivolous or politically motivated allegations of aggression and protect military missions based on self-defense, humanitarian intervention, or legitimate purposes. So I think the Obama team deserves credit for opening with the argument that defining aggression is a matter for the Security Council. And they were able to get helpful language in the annexes. They also made some helpful changes to the Belgian amendment that expanded the list of weapons whose use are considered war crimes under the Rome Statute. But the relative success of on these matters doesn't negate our pre-existing concerns about the ICC. In both Rome and Kampala, our red lines were knowingly crossed and not sufficiently addressed. In both conferences, the states parties went their own way. I have no quarrel with this. The states parties to the Rome Statute have created an ICC to their liking. It is not to our liking. Its broad autonomy and jurisdiction still invite politically motivated indictments. I therefore think the question of whether the U.S. should change its relationship to the ICC after Kampala was largely answered by the states parties themselves. Twice, in fact. Between Rome and Kampala, they had 12 years to think things over, and they reaffirmed an overall vision we do not and cannot completely share. I don't think this fact can be overemphasized. Between the bookends of Rome and Kampala, you have the 2 terms of the Bush administration, where I served, and perhaps I can say a few words about our approach to the ICC. When President Bush assumed office, President Clinton urged him not to submit the ICC treaty to the Senate for ratification because of its, quote, in Clinton's words, significant flaws. So the Bush team went to work and for over 2 years tried to fix these flaws by seeking the necessary safeguards to prevent a politicization of the judicial process. I think we made some improvements. But the significant flaws identified under President Clinton endured under President Bush. In 2002, when the ICC was ratified by enough countries to bring it into force, that was the end of the process for us. And we informed the Secretary General, Kofi Annan, that we didn't intend to ratify the treaty. We unsigned the Rome Statute. We then took a number of steps to protect once the Rome Statute was then established, once the court was established, we then naturally took a number of steps to protect our military personnel, officials, and nationals from ICC claims of jurisdiction. And some people were troubled by these steps. And some opposed the decision to unsign the treaty, because there is always the argument in international diplomatic circles that it's better to be involved than not to be involved. I think there's at least a minimal element of validity to that. But the far greater risk consisted of giving the ICC institutional validity, given how badly the foundation was poured in Rome. It lacked safeguards against political manipulation, it possessed authority without accountability to the Security Council, and it violated national sovereignty by claiming jurisdiction in some circumstances over the nationals and military personnel of non-party states. These concerns were ignored or outright opposed during not only the Bush administration, but across 3 administrations. So the steps we took after the unsigning of the Rome Statute were a natural and reasonable response to years of failed bilateral and multilateral negotiations to reach a mutually acceptable deal. Since the state parties wanted a court that could claim jurisdiction over non-parties, We sought legal protections to preclude nations from surrendering, extraditing, or transferring U.S. persons to the ICC or third countries for that purpose without our consent. We signed over 100 Article 98 agreements, and I think after Kampala, the Obama administration should confirm and endorse all existing Article 98 agreements. I don't subscribe to the argument that the Bush administration was to blame for not ratifying the ICC. History tells a different story. The decision to unsign the treaty may have led to that mischaracterization, but the record shows that we engaged vigorously in negotiations, and even after we unsigned the treaty, we didn't stand in the way of Security Council recommendations. We abstained on Resolution 1593, which referred the Darfur situation to the ICC in 2005. We also agreed to allow the Special Court for Sierra Leone to use the ICC facilities in The Hague for the prosecution of Charles Taylor. After the unsigning of the Rome Statute, we took a fairly pragmatic approach to the ICC that involved a cost-benefit analysis. We didn't stand in the way of an ICC investigation when we judged it important to U.S. interests, but we never backed down from our red lines. Let me close by recalling one episode from the Bush administration concerning the ICC that vividly illustrated for me our concern about the ICC's involvement in situations that are overwhelmingly political and foreign policy concerns. When the ICC prosecutor Ocampo asked the pretrial judges to issue the arrest warrant for Sudanese President Bashir in mid-July of 2008, it really threw the Europeans on the Council into total disarray. France and the UK wanted the Council to invoke Article 16 and defer the investigation and prosecution of President Bashir. They wanted language in the resolution renewing the mandate of the UN peacekeeping mission in Darfur, known as UNAMID. Both France and the UK had strongly criticized the United States for our efforts to protect our military and our officials from the ICC. So it was a surreal moment to be at the table with them, arguing against their request to defer an ICC prosecution. For all of their posturing, at the end of the day, they were quite prepared to interfere with the ICC's prosecution of an individual responsible for genocide. And the UK and France got their way. They inserted language in the UNAMID renewal that said the Council would be willing to discuss freezing any ICC indictment. We strongly opposed the language and suggested a technical rollover of the UNAMID mandate. The Brits called the vote in the Council and we abstained, which was truly shocking to people, given our funding and support for UNAMID. Our position of the Council was that if you're going to get serious with Sudan and refer this to the ICC, then be serious. And don't try to have it both ways by referring the matter and then interfering with the prosecution. We said in our Council statement that the language added to the resolution would send the wrong signal to the Sudanese president and undermine efforts to bring him to justice. We had determined that the pursuit of justice in Darfur, even through the flawed ICC, was too important to defer. It also happened to be the best of some pretty bleak policy options at the time to move the needle in Sudan in a positive direction. Overall, I think the Council referral was to answer the mail to, quote, do something on Darfur, since no one was serious about getting tough on Bashir. Having leveled this criticism against the Council, the Security Council nonetheless has primary responsibility for maintaining international peace and security. But one of the significant flaws of the Rome Treaty is that it removes this existing system of checks and balances and places too much power in the hands of the ICC prosecutor and judges. The Council is an imperfect body, and I've voiced my criticisms of it many times, but I am particularly wary of an entity that seems designed to compete with or replace the Council. Kampala has not resolved the significant flaws first identified by President Clinton and continued by Presidents Bush and Obama. We should therefore, I believe, neither sign nor ratify the Rome Statute in its present iteration. Thank you.
Well, I'm very glad to be here and do want to express my thanks to the Federalist Society for convening this discussion. And I'm going to try to make 3 points in my time up here. First, I want to say a little something about a component of the Kampala conference that hasn't gotten attention from our previous speakers, the stock-taking exercise. Say a word about that. Add a few thoughts to the description that Professor Scharf laid out in regard to the crime of aggression, and then wind up on the point about the Obama administration's relationship to the ICC. First and foremost, the Kampala conference, I think, was an unprecedented event in that you had representatives, most of them lawyers from more than 100 governments, gathered to discuss, first and foremost, one, the outstanding challenges that face limiting the impunity all too often associated with mass slaughter of civilians, the use of rape as a weapon of war, and the displacement of populations on the basis of ethnicity or religion or race. It consisted really of 3 components. One, the high-level diplomatic statements that took 2 days. 2, the stock-taking component I'm going to describe. And then 3, the principal focus, which was work on completing a definition and the modalities for operationalizing the crime of aggression. Stock-taking was really an effort to get these government officials, as well as officials from a number of the ad hoc tribunals that have been referred to face and share experiences with governments on some of the most outstanding challenges facing not only the ICC, but the effort by national courts as well to limit impunity. I'll talk about 2 of those. First, complementarity. Of course, the ICC is a court of last resort. As a human rights activist, I see the obligation of states as being the first line of defense when crimes against humanity, war crimes, genocide occur. All too often, states are unable or unwilling to investigate and prosecute those crimes. And in those moments, in order to limit the impunity that would otherwise exist, there's the need for an international mechanism. I think that's the rationale for all of the international courts, but particularly for the ICC. The challenge is strengthening national courts to be able to go forward and do the investigation and prosecution that they should be doing. This was one of the stock-taking topics that was focused on in Kampala. I think what emerged from that, I hope what emerged from that, was a better understanding of what the role of the ICC is, a limited but catalytic role in bringing donor state attention to areas in national practice, be it forensic examination, witness protection, etc., that need assistance and buttressing from the outside, and how to navigate the tricky interface between lack of political will on the part of national authorities to investigate and prosecute these crimes, and the lack of capacity to do so. I think in this discussion, important seeds were sown that need to be harvested, not so much by the ICC, but by donor states that are strong supporters of the rule of law. And I think this will be a concrete value added that the Kampala Conference, the ICC's Assembly of State Parties, and donor states meeting outside of the ICC context will be able to address. There was important discussion on the interface between peace and justice. How to go forward in achieving both necessary objectives without sacrificing justice under the erroneous conception that justice is somehow contrary to a meaningful peace. I think there was some greater clarity shed on that difficult conceptual and practical problem that is going to need to be further refined and implemented in practice. I'm glad to say more about this stock-taking component during questions, if you have any. But I don't want to shortchange the crime of aggression. Human Rights Watch had a particular position on this crime. We had said we had concerns. We had concerns because we thought there was a potential for example, here's an example, Colombia invades Ecuador or sends a military mission to Ecuador to wipe out a suspected FARC guerrilla base. Easily the Ecuadorian government could claim the crime of aggression and want the ICC to get involved. We saw the crime of aggression is potentially opening the door to many disputes that don't belong at the International Criminal Court. And we felt that was a concern that needed to be addressed. We also had concerns very closely linked to that, to the Security Council being the sole determiner, the gatekeeper for the crime of aggression. And the theory underlying that concern has to do with the separation between judicial and political bodies. The Security Council at the United Nations, whatever else one says about it, is a political body. Its control that is telling the ICC when it can go forward or not go forward over a crime within its subject matter jurisdiction would be weakening the judicial independence that any court, and this court in particular, needs in order to be legitimate and credible. In Kampala, I'm not going to repeat Michael Scharf's description, but in Kampala, a compromise was struck. I think from the U.S. government's perspective, I remember in May 1998 meeting with then Secretary of Defense William Cohn in his office in the Pentagon. This was a month before the Rome Conference. And Secretary Cohn at that point was looking for an ironclad guarantee that no U.S. personnel would ever be prosecuted by the ICC. As regards the crime of aggression, I think the compromise includes an ironclad guarantee that there will not be a prosecution by the court against a U.S. national. And that is because, as Michael Scharf said, there's a non-state party exemption. And at that point in time, when the United States ratifies the Rome Statute as a state party, as has been said, it can opt out. So I think that's a danger that has been addressed by the negotiation in Kampala. I have serious concerns about that. I think that reinforces the unevenness that exists in the international justice landscape, but that's what was agreed. And whether I like it or not, that will be, most likely in 7 years' time, part of the statute. I want to say a word about the 7-year delay, to say that I think that gives the court time to get itself stabilized and consolidated. I think it gives its assembly of state parties the opportunity to explain what this crime of aggression will allow and not allow the court to do, because Another of our concerns had to do with the expectations that would be created that the court would not satisfy with a rather limited definition as was adopted in Kampala. So we're going to be pressing the court and its assembly to get on the case and do adequate explanation to try to minimize some of those inordinate, excessive expectations of what will be done. Now, taking all this on board, let's look at what this means for the Obama administration. I think the U.S. delegation did a good job in Kampala. It was a negotiation. It didn't get everything it wanted, but that is the very nature of negotiations. I think the road forward involves increased engagement and support by the administration. We certainly saw that at the tail end of the last administration. And I agree with Brian's characterization in the Security Council's renewal of the UNAMID resolution. The United States increasingly, practically, not conceptually, not ideologically, but in the last years of the Bush administration, in regard to Uganda, in regard to Darfur, was very supportive of what the ICC was trying to do in bringing those responsible for these crimes to justice. I think that's the proper path for the Obama administration to pursue, and we will be pressing them as best we can to follow that path. I think ratification, well, the United States Senate took 40 years to ratify the Convention to Prevent and Punish Genocide. I'm not expecting ratification of this treaty anytime soon. So I think it's a bit of a red herring to get our knickers all in a twist about should they ratify, should they not ratify. Politically, that's not the reality. And I think the time allows a closer relationship, a supportive relationship, but not a slavish relationship to the ICC, where the United States sees the ICC advancing its interests, such as Brian described in regard to the arrest warrant against Omar al-Bashir. It should support the ICC. It would make no sense to hold back. And I'm going to close on a note that I feel strongly about, because I think there needs to be intellectual honesty and accountability. And I disagree that the steps that the Bush administration pursued from 2002 to 2005 were reasonable. But more importantly, I would ask you all to look at the disastrous results of that policy of search and destroy. I think that was the Bush administration policy towards the court in that 3-year period of time that alienated our closest allies around the world. The agreements that Brian referred to, I remember August 2002, the first state that ever signed one of those agreements was Romania, and that was because the Romanian president was at the White House and had dinner with President Bush at the time. What's interesting about that agreement is that it required ratification by the Romanian parliament. The Romanian parliament never ratified that agreement. So you talk about 100 agreements. Many of those agreements weren't worth the paper they were written on. What they netted for the United States was alienation and estrangement from many of its closest allies and a cutoff in assistance, military assistance, to states like Kenya, who find themselves fighting international terrorism, but were deprived of forms of U.S. support because they refused to sign one of those agreements. I would say Condoleezza Rice got it right in March 2006 when she said, with our ICC policy, we have shot ourselves in the foot. Now, I think to go back and take the gun and shoot ourselves in the foot again would fail to really learn from the lessons of past practice. Thanks very much.
Jeremy?
Ed Williamson, who decided the order in which we would speak, seems to have thought that give everyone else a chance to be calm, and then someone at the end could disrupt the emerging harmony. I think that's my job. Michael Sharp started talking about Nuremberg. These discussions always go back to Nuremberg. Nuremberg was great, and we have to pick up the baton and carry it forward. That's maybe a good place to begin. With all respect to Michael Sharp, who I regard as a friend and very valuable scholar. I think starting that way, not him in particular, but everyone who does that, is a symptom of the zaniness of this whole enterprise. The important thing that happened in 1945 was not the trial, but the surrender. We keep hearing that Europeans are very traumatized by the Second World War. Okay, the generation that actually was traumatized learned that it's not safe to be a neutral, as many of them had been in 1940 before they were invaded, and they set up NATO. Almost all I think all the countries in Europe that were in the UN supported the establishment of a Jewish state in Palestine. They said that's an answer. The Jews in the future should be able to defend themselves. The answer at the end of the Cold War to the challenge of not just aggression but evil in the world is, let's have a court. That'd be great. Why didn't they think of that in 1940? If only we'd had a prosecutor somewhere to say, no, wait, stop, no. Then all the horrors of the Second World War would never have happened because everyone would shrink from a prosecutor. Now, we all know that is crazy, but somehow we bury that thought, and we bury it very deep. What has just happened is 100 nations, or however many it is, who participated in this conference, have voted a definition of aggression which, if it had applied in the 1930s, would have meant that France was committing aggression when it sent troops into the Rhineland, if it had done so, to say, no, wait, Germany, you cannot send troops here. You promised in the Versailles Treaty not to do this. They would have been enforcing their treaty rights. That wouldn't have been aggression at the time, and in retrospect, even at the time, a lot of people thought, oh, that was really a mistake. When Germany annexed Austria, when Germany did a whole series of aggressive things and there was no response, people in retrospect said this was why we had this terrible war, because there was not an effective response. What we've now done is said, no, any use of force is aggression. If you have that view of the world, you are inviting dangerous people to do dangerous things, and you are disarming the responsible governments in the world from acting. And that is what we have done. The gist of this, to say it straight out, is the UN Charter is very, very vague, and we've been arguing about this for 60 years, how to interpret the very vague general terms of the UN Charter. In 1974, the General Assembly passed this resolution explaining what they thought is the interpretation of the UN Charter, which is basically, don't do anything. And that is a third world view, right? Which is anything you do to us is wrong and bad. What's essentially happened at Kampala was that definition, which no NATO country supported in the 1970s, has now become the international standard. And what we're now talking about is, well, procedurally, are there enough safeguards, holdbacks, equivocations that it's really okay that we've enshrined now a third world understanding of what aggression is. The gist of this is the definition abstracts completely from purpose. Were you threatened? Did you need to do this? Did you have responsible motives? None of that matters. The definition itemizes. You cannot use your Navy to impose a blockade. You cannot use your Air Force to have bombardment, which of course would include missile strikes. You can't use commandos to have a quick incursion to release hostages. All the things, and by the way, you can't use your treasury to fund guerrillas of people like the Contras in Nicaragua. All of those things are aggression. What is interestingly missing is facilitating or in any way helping guerrillas if they're not an instrument of your state policy. Let's not speak abstractly. Let's talk about Iran and its support of Hamas and Hezbollah. Is that aggression? I think they have an ironclad defense, which is, no, it isn't aggression because we're not controlling them. They're not an instrument of our state. We're just helping them, and they're just doing whatever they're doing. If there is a response to that kind of provocation of guerrillas doing, let's say, suicide bombing or shooting off rockets, Lebanon will say, it's not us. We didn't do it, which they didn't. It happened from their country. Maybe the Palestinian Authority in Ramallah says, rockets from Gaza, we didn't do it, it just happened. Pakistan, for sure, will say, raids into Afghanistan, we didn't support that. It wasn't our policy, it just happened. But still, in every one of those cases, the response of the state party, the definitions invite you to say that is aggression. There's no reference to purpose, legitimate needs of self-defense. Of course, it does nothing at all to strengthen the court's enforcement capacity. There's no provision in any of this. There was a reconsideration of how the court's done over the past 7 years. I'd be interested to hear more about that. It hasn't done anything. It's not capable of doing anything. What are we talking about? They indicted President Bashir of Sudan. That was great. Everything, all the problems in Sudan were ended by that. No, of course they weren't. The African Union celebrated him as a hero. The Arab League embraced him. He was just reelected as president, right? It didn't do anything. So what we've basically done here is to say, if there are problems in the world, we'll have these lawyers, and they'll handle it. We all remember the lawyers did a great job stopping the genocide in Rwanda. Lawyers have done a great job stopping all kinds of murder and terror in the world. Lawyers are doing a great job now disarming Ahmadinejad. All of that sanctimonious, oh, Nuremberg was terrible, oh, we resolved, we never. Okay, now who is the world leader who speaks most like the people on trial at Nuremberg, right? It's President Ahmadinejad of Iran, who talks just like a Nuremberg defendant. It didn't happen, that's a lie, the Jews just say it, and they deserve to be killed. This time we'll really do it, right? The guy is an open Nazi, and the world is saying, oh, he's getting a nuclear bomb. Interesting. Well, let's have some lawyers talk about this, right? I don't know what should be done, but the one thing that should not be done is to enact a standard which says, whoever acts decisively to disarm a raving Nazi lunatic trying to get nuclear weapons, that is aggression, that should be stopped, right? This is madness. Let me say one last thing, which I think is much to the point, which is if you care about peace, the way we get peace is by saying, okay, everybody back off. I mean, there's two ways. One is victory, that's the best way. If you don't have a commitment to victory, you try to negotiate. And one of the things you always do in a negotiation is say, okay, we're all very sorry, we'll never do it again, right? Okay, all back off. What we've done is to say, no, we cannot have a negotiated solution in any of these disputes around the world because the prosecutor, in his judgment, will just go forward. Yes, the Security Council can hold him back for a year at a time, but any troublemaking country that wants to make trouble can just say, no, we veto the resolution to suspend him, so he goes forward. So just think about the Mideast or think about Afghanistan. At some point, we're going to try to resolve something and have some negotiated. Well, you want the ICC prosecutor in the background saying, no, sorry, no, both sides have to be prosecuted, or one side, someone does. All right, when you need to negotiate a solution, you do not need to have an independent prosecutor prancing around saying, my view of justice is. Why does it matter what his view of justice is? Who is he? So, I want, before I sit down, which I will do in just a minute, to just step back from the point that I've been making, that in principle this is a terrible idea. In principle this is really utopian and crazy. And just address the points that everyone keeps making. Oh no, we have ironclad assurances, no American will be prosecuted. There are all these safeguards. This doesn't reassure me very much for two reasons. One is an American can be prosecuted if Harold Coe or somebody says, no, we should vote for the resolution because we, as Hillary said, we want to cooperate. The UN is authorized under this amendment to the ICC statute, the UN Security Council, to say, even a country that did not ratify, even a country that put in a declaration saying we don't want to be part of it, you can leap over that if the Security Council wants to leap over that. Do you think it's hard to imagine a situation in which the Obama administration says, we were tangled up in something that was complicated, but we have nothing to fear, we don't believe it was aggression, we vote, at least we abstain. Let the UN investigate what's happened in Afghanistan. It's necessary also to prosecute the Pakistanis, the warlords, the this, the that, and we don't mind. If you think that that's inconceivable, I just remind you, it's on our resume. We did this already at the UN. This happened in the Clinton administration. When they set up the Balkan Tribunal, it had jurisdiction over Americans. When Secretary Cohen was saying, oh no, I want ironclad assurances, too late, too late. Already at that time in 1998, there were people looking into, wait a minute, the United States, you're involved in bombing and maybe. So we've already agreed to it. So the idea that we would never agree to it, of course we might agree to it. And that would be one person, the president, allowing everybody in the military, and who knows who else, to be open to prosecution because he thought it was a good deal and really he trusted, right? So don't believe in those safeguards. And the second thing is, think about what this says to the world. We agree in principle that the most fundamental questions of international law, the most fundamental questions of international justice, the most fundamental questions of international relations, namely, when can you use force to defend yourself? When is it a just war? When is it proper to act because you feel threatened? Those questions can be decided by a bunch of lawyers in The Hague. We agree with that in general, but we just exempt ourselves because we're so important. How long do you think we're going to be able to maintain that? I mean, we are basically saying to the world, yes, this European view that you don't need to have NATO, you don't need to have military capacity, you don't need to have the capacity to defend yourself because there are lawyers on the job. We agree that that's reasonable. It's very sound. We just want an exemption for ourselves. How long going forward do you think we're going to be able to maintain that? And do you think we're going to be able to maintain that for our allies? You know, we want to be exempted, and also the various people involved in the mission with us should be exempted. I think that'll be very hard to maintain, and at the very least what you have going forward is people are will be in the future even less inclined to use force than they are now. We've seen this already. This is not hypothetical. Our NATO allies voted to say, yes, let's go into Afghanistan, and when we turned around to see which NATO allies are with us, the Brits, Canadians. The French are not there, the Germans are not there, the Italians are not there, go through the list, right? It's too complicated, it's too dangerous, someone might get hurt. You set up the ICC and you say to them, no, come with us, you can exempt yourselves. It's controversial for them to exempt themselves, so probably they won't. So probably they'll just hide behind that screen. So you can see going forward where this is. It just makes it harder, much harder, ever to use force in those circumstances where force may be the only thing to save us, because really, if you're talking about the threat of aggression or evil in the world, it's just childish and escapist to think you're going to be saved by lawyers. Thank you.
Well, thank you all very much. Let me start with just to see if anybody wants to just have a quick little intervention to respond to anything in particular that any other panelists said. Michael?
Yeah, I would, I guess. Just to Jeremy's last points, Jeremy paints with a broad, though entertaining brush, and I'm sure he wouldn't want you to leave here with any misconceptions. So I just want to clarify three things so that you have it right. The first, he said that any use of aggression would be covered. Use of force would be considered aggression. That's not what the resolution says. It specifically says self-defense is not aggression. It specifically says anything authorized, any use of force authorized by the Security Council is not aggression. And then, of course, as I mentioned, it has this very high level of manifest aggression for jurisdiction before the ICC. He said no country had NATO country had supported the 1974 resolution defining aggression. That's not true. All the NATO countries joined the consensus on that resolution. And finally, he says an American, specifically a low-level person in the military, could be prosecuted if the president decides to abstain on a Security Council resolution. And the elements of the crimes for this resolution on aggression says that it only applies to the top leaders. This is not a crime. that would be subject to any lower-level people. So the military card is not one that should be played here. And I just wanted to clarify those 3 points.
Wait, Micah, could you just read out for us what is the language that you think protects the right of self-defense?
Yeah, the right of self-defense?
Yeah, you said,
Yeah,
self-defense,
it's
that
got to
can't
be,
ever aggression.
it's defined, it has to be a use of force in violation of the UN Charter, and self-defense under Article 51 is specifically authorized by the UN Charter.
You know, we always agree when the UN Charter authorizes self-defense, don't we? We always agree on that.
They've taken that account by saying that it had to be a manifest violation, meaning it had to be clear and egregious. So if we're not in agreement, then it's not going to be subject to the ICC's
We
jurisdiction.
never disagree about when things are clear.
Which is why a very small number of cases would ever, it'd only be like an invasion of Poland or an invasion of Iraq against Kuwait that would be so clear and egregious that it would be considered a crime of aggression.
Just for
under that.
example,
Let's see,
the
let's
entire
just-
world agreed with us about Iraq, right? That was not manifestly wrong.
All right, so I'm going to leave it at that.
Okay, Richard?
I guess, just my contribution here is that, Jeremy took us to, 50,000 feet view. And it's an interesting perspective from that height. But no one is making the claim that the International Criminal Court is the panacea to all the world's problems that we acutely feel, some of which you enumerated. The issue is when you have 40,000 children abducted by Joseph Kony's Lord's Resistance Army in Uganda, when you have however many hundreds of thousands of Darfuris killed by Omar al-Bashir.
Richard, I'll give you about 10 seconds to indicate
Is-
why the ICC has stopped that.
It hasn't stopped it.
Okay.
But the time frame is a little accelerated. In other words, I think we've got to take a longer view in terms of how quickly all this will come to pass. My point is, I have to say, Jeremy, that I think you take us to a world where law doesn't really matter, words don't matter. The Federalist Society is based on law, based on the Constitution. If we take the approach that these words don't matter, where are we? Where does that leave us, except back in a very ugly Hobbesian world? I think I think people who believe in the rule of law.
Well, I'm going to interrupt you and just cut to a very, just a sort of a technical discussion. And we're going to continue this little round here with some questions I've got. And as I said, I'm going to try to have some time left for questions from the floor. But first, just in the terms of the respect of the rule of the law and the following of what, and compliance with the words that are already written in the Rome Statute. The provision for amendments to the Rome Statute say that the first step is you have an amendment if it cannot be reached if agreement cannot be reached on an amendment by consensus, and it must be approved by 2/3. That's paragraph 3 of Article 121. Paragraph 4 says that except with respect to amendments affecting the crimes, an instrument it's not clear to what part of what follows that exception applies to. I think it's fairly clear from a common sense standpoint, and from the wording of it. But anyway, it says that an amendment shall enter into force for all state parties 1 year after instruments of ratification or acceptance have been deposited by 7/8 of the state's parties. Then the exception in 5 is that appears to me to say that the coming into force part of paragraph 4 doesn't apply to a state party that says that it does not accept the amendment. Now, there is the other alternative to interpreting that is that actually paragraphs 4 and 5 set up alternative forms of amendments, and that is basically what the state's parties adopted, so that there will never be a requirement for a 7/8 ratification of these Kampala amendments, but instead there will be just a two-thirds vote followed by a 30-member ratification. So, where is the? Is there any support in the negotiating history in Rome that supports this interpretation? I mean, am I wrong to be worried about this interpretation? I'll start. You, Michael?
Yeah. Actually, both at the experts meeting that we had at Case Western and during the review conference, and then subsequently, there have been a number of emails by, for example, Stephen Baraga, who is the deputy to Christian Vanavasser, who is the president of the Assembly of State Parties, has been engaged in these emails trying to explain this. And the reason he has to explain it is because there's quite a lot of puzzlement. The problem is that the amendment process is, under the 1998 treaty, self-contradictory and ambiguous. And what they have created is not wholly satisfactory for those of us who want to see any particular clause complied with as scrupulously as possible, but rather what they're trying to do is make sense of these self-contradictions, citing the Vienna Convention that says, look, sometimes treaties under the negotiating process, which is a little bit like the way sausage is made, end up with ambiguities and internal contradictions. And when that happens, you have to look at the spirit, you have to look at the negotiating record, you have to make sense of it. You don't have to be a slave to things that would be crazy results. It's the same thing we apply in the United States when interpreting a domestic statute, and this happens all the time domestically as well, so it shouldn't be a shock. So in fact, that's how they got to where they are. Whether if you're really someone who wants every word to have the meaning that it says, you'd be very unhappy with that. But if you're someone who sees the way that statutes have been interpreted for 234 years in the United States, when this happens, you'd say, okay, I understand what's going on.
But if the leader of the U.S. delegation to Rome comes home and says that don't worry about amendments, it takes 7/8 vote for them to come into force, he has a little egg on his face, right?
For this, well, see, it goes back to the fact that the original 1998 statute anticipated a crime of aggression. And so the debate was, is this like creating an amendment to the jurisdiction of the court, or is this like filling something that was invited to be filled? That's why this is not, that's how they have distinguished this from other amendments. So a regular amendment, all other amendments to the court statute will require the 7/8 parties, but because of the unique nature of a crime of aggression, which was anticipated in 1998, they have tried to get around that with the 2/3 approval process.
Just another thing, given the significance that that is applied to the ability of the U.S. to opt out of the crime of aggression if it should accede to the Rome Statute. I don't see that written in black and white anywhere. Have I missed something?
Yeah, well,
great
actually,
supporter of the words here.
And that is the paragraph that says, let me find it, I'm sorry.
Okay. I'll give you all a couple of minutes on that, and we'll come back to it. Brian, I don't know whether this is something that but given that the Article 98 amendments, I guess, were done in the Servicemen's Protection Act, what impediments are there in the Servicemen's Protection Act for a general support going forward of the ICC?
Well, I think it's reasonable to bring up the Article 98.
Could you bring the microphone?
Oh, I'm sorry. When Richard was talking about Article 98, I would just sort of, a couple things came to mind. Article 98 is the Rome Statute. We are using a mechanism contemplated by the Rome Statute itself to protect our military officials and our nationals and our officials. So I don't think there's anything out of bounds.
I'm sorry, let me just, because we're all going to get it sort of tight here on time. My understanding is, and I apologize for not having looked this more clearly, but I understand that there are prohibitions on U.S. officials cooperating with the ICC on certain occasions, and that we probably need some clarification of that in the Servicemen's Protection Act. Let me move on to another question. Why is it that there's so much concern about the ability to prosecute U.S. nationals. Harold Coe made a big point of this in his ASL, in the Q&A following his ASL speech. But yet the basic reason that I've opposed the accession to the Rome Statute is that U.S. Officials can be prosecuted by the ICC for any crime. It's not just the crime of aggression that gives me pause. Why does one make such a big distinction there?
Okay, well, let me answer that. Yes, you have hit upon an asymmetry in that under the original Rome Statute, any country, even a non-party, whose nationals commit crimes in the territory of one of the state parties can be subject to the ICC's jurisdiction, just like they could be subject to the national prosecution of that state. The United States did not successfully get at Rome in '98 with respect to genocide, crimes against humanity, and war crimes what they did successfully get at Kampala in 2010, and that is an absolute ironclad provision that says it doesn't apply to non-party nationals. And so what I guess you're suggesting is, you know, they succeeded in aggression, they didn't succeed on these other crimes, we should be very worried about the other crimes because that's more realistic. And so,
well, the last time I checked, the prosecutor said he had received over 430 referrals for what the U.S. had done in Iraq. And the reason he didn't exercise jurisdiction was because Iraq is not a party to the Rome Statute.
Yeah. I mean, I think that's true. The United States should be concerned that this could happen, but it's not unique because the same thing that can happen before the International Court can happen when U.S. nationals act in another country. You are subject to that country's laws. And now under universal jurisdiction, countries are becoming more and more aggressive about prosecuting foreigners for war crimes and crimes against humanity and genocide done within their borders and sometimes done outside their state.
Moving on to the often asserted statement that the Bush administration made a horrible decision in not participating in the drafting sessions that led up to the Kampala Review Conference. I must say that first, my idea of John Bolton or even Brian at those drafting sessions doesn't strike me as something that's likely to produce tremendous results. But given the, for lack of a better word, treatment of the U.S. delegation at Kampala and the results of Kampala, would participation have really made that much difference?
Well, consider the fact that Russia and China did participate. While we, after 2002, unsigned, yet Russia and China participating in all of these things. Clearly, the ICC, to enhance its legitimacy, would like to have Russia and China on board. It's clear that that engagement produced nothing in the way of moving it in the direction that would make it more rather than less likely for the U.S., Russia, and China to be parties to this. Whether it's the UN Human Rights Council or, and obviously, I think the ICC and the UN Human Rights Council are two areas where there's a real sharp divide between the parties and the administrations on the fruits of engagement. And we found that in places like the UN Human Rights Council, even if the Brits and the French are making our arguments, in which they usually hide behind us often, they kind of let us lead the parade. But even when we're not there, they make the arguments, it really doesn't produce that much of a different outcome. So my own view is even if we had engaged, it would have been probably some qualified success at the margins, but it wouldn't have been enough for us to sort of put the full faith and credit of the United States behind it.
You know, I actually think that what you saw in Kampala was a complete success of negotiation. It actually showed that even though the Bush administration hadn't engaged earlier, that the Obama administration played catch up pretty well. I think that Stephen Rapp was brilliant to start his speech by saying the equivalent of Ich bin ein Berliner, I'm one of you. And I think that they embraced the American delegation led by someone who had been a prosecutor of an international criminal court who said he believed in the ICC. And that's why you have an ironclad guarantee that no American can be prosecuted for the crime of aggression. They succeeded. I don't know how you can look at Kampala as a failure.
Well, I never said it was a failure. I said the Obama administration deserves a lot of credit. But He had 2 red lines, and neither were honored.
Yeah, I think the lesson to learn from the 7-year or 8-year period that U.S. negotiators were not involved in the ICC process is an important one, in that the definition of the crime, I believe, would have looked a lot different had a lawyer of the capacity of Colonel Lietzau, who really played a crucial role in Rome in drafting the war crimes segment of the statute, as well as the subsequent elements of crimes document. I mean, U.S. negotiators didn't get everything they wanted. That's the nature of negotiation. But they were tremendously influential. The definition, I believe, would have looked different had a high-level, competent negotiator from the U.S. been at the table. And to answer your question, Edwin, it's in paragraph 4, the language about opting out. If the United States, for example, were to become a state party, it says there will be no jurisdiction arising from an act of aggression committed by a state party unless that state party has previously declared that it does not accept such jurisdiction by lodging a declaration.
That clearly applies to states parties at the time, who are states parties at the time of the adoption of the amendment. This is for someone who comes along later and says,
Yes.
oh, wait a minute, by the way, that amendment back then, is it?
Yes. So if State X were to ratify 10 years from now, it would issue a ratification of this amendment and then an opt-out if it wanted.
Relying on that language.
Relying on that.
Let's just say the language is not clear.
Yeah, I was going to say that at the time. Actually, what I was told was that, in fact, in paragraph 5 of Article 40 of the Vienna Convention on Treaties, there is a general principle in this treaty that the United States is not a party to, but we do generally sort of indicate that we'll follow those rules that says that a party acceding to a convention may elect not to be bound by amendments to the original document, the theory of which I'm not sure I understand. Okay, let me just run through very quickly. I was going to ask, I think most people have talked about whether or not this should change the U.S. approach. My understanding is that there's still very strong voices within the administration in favor of accession, but I would also assume that the DOD is not quite on board. I would like to hear a couple of comments on the understandings, particularly the paragraph 5 of the understandings that says basically that it was 4 and 5, basically that notwithstanding the fact that we've got 110 countries agreeing to this, that this isn't part of customary international law, and that second, that it is not to be the basis for any sort of universal jurisdiction. Where do we get those principles of customary international law? I mean, when I have my arguments with Jeremy, who's a big supporter of customary international law, as indicated by his opposition to the Law of the Sea Convention, that he doesn't tell me about that aspect of it. So in the customary international law theory, what is it that says, we're going to stand up here and hold our hands up against the 110 nations who are bound by this provision? Do we have any examples, precedents?
Yeah, I mean, treaties do not automatically create new customary international law. And to the extent that some countries, including the U.S., thought that the provisions defining aggression in this treaty went beyond the much narrower definition of aggression in customary international law, the United States, who proposed these two understandings, wanted to make sure that its courts and other courts around the world would not start interpreting the customary international law crime of aggression as broadly as the treaty-based crime of aggression that only applies for the ICC statute. I think that's perfectly consistent with the Vienna Convention and with the way custom has always been interpreted. When there's a treaty, including the Law of the Sea Treaty, when there's a treaty that defines something like piracy that may be a departure from custom.
I'm going to, unless somebody wants to make a quick intervention, I'm going to now open the floor up for questions. And David Ray has a microphone, so please let him get to you, and please state your name and your affiliation.
Mary Ann McGrail. I'm on the DC Bar International Law Steering Committee. Under what circumstances, if any, could the perpetrators of an event such as 9/11 have been prosecuted under the current definition or the working definition of the crimes of aggression?
Marion, I think they could have been prosecuted under the provision, Article 7, dealing with crimes against humanity. I think
I'm
it.
talking about the Kampala provision that has
Right.
been discussed.
Okay, I don't see, maybe others do, I don't see that being relevant in terms of their prosecution as a Al-Qaeda being a non-state actor. I think they could have been prosecuted theoretically under the crimes against humanity provision.
I mean, I could add to that. If you assume that the Taliban government, the official government of Afghanistan, was behind the Al-Qaeda attacks of 9/11, which there seems to be some evidence of, then Afghanistan committed a crime of aggression against the United States through its support and involvement in 9/11. And what would have to happen if that happened today is that the Security Council would have to refer the matter to the ICC prosecutor, or the country of Afghanistan, which is a party to the ICC statute, would have had to have not opted out of the jurisdiction of aggression, and the Security Council would not have done one of those red light resolutions that we talked about. Then the prosecutor could bring the case to the ICC pretrial division, and if a majority of the judges agreed, they could open an investigation, and that's how that would have been handled today.
I just want to endorse what I take to be the spirit of the question. This is not a technical point. The language, this is why my fellow panelists are being evasive here, or being so, well, no, not exactly. The language of aggression is only a state can commit aggression. Why is it only a state can commit aggression? And I believe the reason for that is the International Court of Justice says you can only defend against attacks from a state. If you're defending against attacks from a terrorist group, well then you can't build that fence, and you can't have a raid, and you can't do anything else, because the right of defense is only against another state. This is extremely important in a world in which so much of the aggression we face is committed by non-state actors, and I don't believe this happened inadvertently. I think this is part of a strategy. The easy thing for Afghanistan to do, or Syria, which is host to all these terrorist groups, is to say, oh, we didn't tell them what to do. It wasn't our policy. We were just giving them refuge. It's just, I mean, in a world in which, you know, lawyers know how to say, no, sorry, this is a different body which just happens to have the same name and in the same office, but it's a different one, so for tax purposes it's different. People can write out a little formula to say this is not the state-controlled part of Hamas, or Hezbollah, or Al-Qaeda, or whoever it is. So I think it's very, very revealing, you know, lacuna in this treaty.
Well, actually, it does say the sending by or on behalf of the state.
On
of
behalf.
Armbands.
On behalf. And they will
let
say
me-
it wasn't
let
on
me
our
finish,
behalf.
Jeremy. Let me finish.
Yeah.
if I may. The sending by or on behalf of a state, which is why I answered the question. I think it would be a tough evidentiary case to sustain to show that the Taliban government had sent Al-Qaeda to bomb the World Trade Towers. And that is a lacuna. But this does get to the point that you raised earlier, that it's not exclusively relating to acts by states. So I just want to balance the record.
I guess they could also claim that they were, under the ICRC definition of membership, they were really doing it as part of their night job, not part of their day job. But that's, any other questions? Brett?
Thanks. It's very interesting. This on? It's a very interesting panel and important panel, I think. There are two questions that I wanted you to clarify because there seemed to be a little bit confusing.
Brett Stevens from Heritage.
I'm sorry, Brett Schaefer with the Heritage Foundation. The two questions up front had to do with one with the amendment process and the second with the nature of the crime of aggression in respect to ICC states parties that haven't actually accepted or ratified the amendment on aggression. The first one was under Article 121.5, which the resolution specifically refers to. Article 121.5 says that any proposed amendment to those four crimes, Articles 5, 6, 7, and 8, which deal with the crimes under war crimes, crimes against war crimes, aggression, crimes against humanity, and genocide, aren't binding on the member states until they actually ratify. So is it your understanding that the amendment, the resolution, would not be binding on any ICC member state until they actually go through the process of ratification and accept that amendment? So they don't have to make a declaration to exempt themselves unless they actually ratify the amendment. Second, in regards to any future amendments to the statute, you mentioned Article 121.4, Article 121.5. Two different processes. One is the 7/8 process, and the second is dealing with what we were just talking about here. And so any future amendment to Articles 5, 6, 7, and 8 would go through the process that we're seeing here with the resolution on the crime of aggression. Just want to make sure that that's your understanding as well. And third, is there any time frame or prevention or anything in the text that would prevent a state from repeatedly exempting itself and declaring itself exempt from ICC jurisdiction over aggression? Let's say that Belgium ratifies the amendment, declares that it's contemplating participation in NATO operation, declares that it was exempt from ICC jurisdiction for aggression, re-enters in after the conflict is over, and then in a future time, again, declares. Is there anything preventing that sort of a check-in, check-out hotel jurisdiction for the ICC on aggression?
So,
Mike, you're all lawyer.
I'll try to be. The understanding of the consensus, which, as I said, was trying to deal with some internal inconsistencies and ambiguous language, is that the 7/8 requirement would apply to the addition of new crimes, like terrorism and piracy, which they are considering adding. And they want to make sure that for new crimes, they don't apply to countries unless 7/8 ratify, and if the particular country that it's going to be applied to has ratified. For the crime of aggression, they decided to treat it pretty much like it's sui generis because it was such a weird provision in the original 1998 document. So they have a different process for that, as we discussed. Now, the check-in, check-out, I think that would be controlled by the Nicaragua precedent of the International Court of Justice, which simply says, yes, a country can withdraw from the ICC statute, but you have to give your due notice, and you can't do so when there is a potential crime against you on the books, so that you are doing this in bad faith in order to avoid jurisdiction and then jumping back in and jumping back out. So I think that good faith requirement and the 6-month requirement would be the two limits to that kind of checking in, checking out. In order to withdraw from the ICC statute, what is the provision? Does anybody
You have to give notice. I can't recall if it's 6 months or a year. Yeah.
Oh, 1 year. I'm sorry, 1 year requirement. Yeah.
Thank you. I'm Jim Haynes. I'm a member of the Federalist Society. Everyone referenced the Nuremberg proceedings, more or less, in discussing this, and I take it that each of you consider it in one way or another, for good or for bad, as pretty much the high watermark of international law and international jurisprudence, and something that we want to do more of. So I wanted to just sort of raise the point of history that in 1939, I guess the behavior of Joseph Stalin and Adolf Hitler was almost identical with regard to Poland. And yet the Nuremberg proceedings pretty much gave Stalin impunity and hung a few Nazis. To the extent that we're looking at the ICC so many years later, aren't we just looking at the time-honored rule that the winners are going to hang the losers? And aren't we just going through a lot of self-delusion and window dressing here to kind of escape from or shield our eyes from that kind of brutal fact of human existence? And there is a peril in doing that, in denying reality. So does anybody want to answer the Stalin question?
Yeah. I think I wouldn't cite Nuremberg as the high water mark of international justice. I think it was a very significant legal development for obvious reasons in terms of holding to account at trial individuals accused of horrific crimes. But what you're flagging in terms of the notion of victor's justice, there was a Soviet prosecutor in Nuremberg, but no Soviet prosecutions. I think the effort for a multilateral treaty is an effort to get away from the phenomena of victor's justice. Will it succeed entirely in the landscape that we have today? I doubt it in the short run, but that's the hope, that law takes on a force and becomes a progressive force, as our own law has done in this country, far beyond what our framers imagined it would. So I think that's the direction it's heading. I can't give you a guarantee away from victor's justice.
Jeremy.
Stalin is the least of it, okay? I mean, this is the most fundamental thing in international politics, when you have to sort of decide, was this justified or not justified? And people disagree. I mean, the way you're telling it, it's really too bad that we cannot have an impartial determination. No, it isn't. If we had an institution that could impartially determine, that institution would be emperor of the world. That is God's job. Right? I mean, there cannot be an international institution that says authoritatively. The interesting cases aren't the Stalin case, where everyone knows that, you know, he was not just an aggressor, he was a psychopath. And for some reason which I don't understand, Human Rights Watch has not been out there saying, there has to be justice, there has to be justice, all those Bolsheviks who killed people have to be prosecuted. Even they say, let it go. But the question is, in the cases that are ambiguous, you want to talk about the Second World War, Britain invaded Norway, a neutral country, because it thought it needed to do it. The United States sent troops to Morocco. We weren't at war with Morocco, with France, which was the colonial power there. We just said, we need to do it. Was that justified or not justified? It was kind of unfortunate for France and for Morocco. Kind of unfortunate for Norway, right? I mean, they all got hurt. Their neutrality was violated. Was it justified? Well, people could disagree about these things. And we're saying, is it going to be victor's justice, or could we impartially determine this? No, of course it's victor's justice, because these things are settled by war. I mean, you hope that the victors behave well, and you certainly hope that the good people are the ones who win. But the alternative is not, let's all hand this off to lawyers who will tell us what justice is and do God's job for him.
All right, and just to chime in, I share your ambivalence about this, and clearly, in an effort to protect themselves, the United States, the UK, and France, and other countries have watered down the statute and created asymmetries so that they will not be subject to the crime of aggression being prosecuted before this ICC, and that means that some countries in the world who commit the very same acts could be prosecuted, and some countries will not be prosecuted. Now, those are some of the political realities to try to create a treaty-based jurisdiction. And what it means is that this court's jurisdiction over the crime of aggression is going to have very little impact in the real world. Just an impact on a few countries. And the only real impact it might have is the symbolic impact, in that it has now defined the crime of aggression in modern terms. It has created elements of the crime which are much more specific than ever existed before. And there might be some prosecutions which will remind people from time to time that this really is something that the international community does not condone. And that's pretty symbolic in the end. I mean, I think this whole thing, and you've hit the nail on the nose. This whole thing is really about debating about how many angels dance at the head of a pin, especially for the United States, because there's just very little exposure and little to worry about, but it's also very little benefit for the same reasons.
Unless there's we'll take one quick question, and it'll be very short answers because we're right at the 2 o'clock mark.
Hi, I'm Deborah Weiss. I have one for Professor Rapkin. I just wanted to clarify. The definition of self-defense only applies to defense against nation states, so that if you're defending yourself against like Hamas or Hezbollah, that would be considered aggression because you're defending yourself against a party that's not counted. And I want to just add one other one. I also want to know if it's possible that eventually the ICC could be binding on self-exempt nations via customary international law or amendments. I think we had this discussion once before. The Law City Treaty has a provision that nobody ever notices that says that they can amend it in such a way that not everybody has to agree to it, and it would impose on the other parties that didn't sign up for it or exempt themselves.
I hope my fellow panelists will agree that this is just factual. The term self-defense doesn't appear. This is people reading into some vague something about the UN Charter, but the term self-defense is not there. What I was talking about was the International Court of Justice has said that's what the UN Charter means. You can defend yourself against a state, but not against non-state actors. And to your other question about, could this be amended? It's very explicit. The UN Security Council, whenever it wants to, can say, let's unleash the ICC on you, even though you didn't ratify it, even though you said, oh no, I declare that I don't want to be subject to the aggression jurisdiction. Whenever it wants to, the UN Security Council can just say, oh, let's do the ICC. Now let's think about, there's only going to be a few countries and they're not too important. I wonder what few countries the UN might want to focus on which aren't very important. You know, just to see whether they did war crimes or whether it was aggression that they landed people on this flotilla off of Gaza. I mean, it's obvious where this is going. And the Prince of Jordan, who's presiding over this, I wonder what countries he was thinking of. I mean, this is just another. Let's have a special version of international law for the particular countries that we like to go after. But I do think in the long run that is dangerous for everybody and not just for Israel. That was the country I was thinking of.
Well, I'm going to bring these proceedings to a halt. I'm just going to end up with a comment, though, that one of the things I do find curious about the way this has turned out is that, I mean, one area in which I disagreed, I think, with some of my colleagues in the conservative base is that in the concept of being able to go after a violator of a treaty, notwithstanding the fact that the violator either is not a party or is a national of a non-party. For example, I have no problem whatsoever going after a committer of genocide, even if there theoretically was it was committed by a state which was not a party to the Genocide Convention. I was always concerned about how the people such as the U.S. who are called upon to do a lot of things protect themselves against incorrectly brought decision. But I thought that that if the ICC could not go after bad guys, the bad states, even though they were non-state parties, then they were sort of lost or something. So what we've done now is we've come up with what is supposed to be the most serious crime of all, well, one of the most anyway. Obviously, genocide and others are pretty bad too. The crime of aggression, and we've basically said, look, don't want to be bothered by this, just don't join. It doesn't seem sort of strange to me. But I think we've generated enough questions and discussions and so forth that I think we should definitely look forward to a lot of reruns of this over the next 7 years.
That's for sure.